Hello, my dear students. Today we are going to discuss about the concept and the concept of temporary injunctions and also the drafting of an application for temporary injunctions under Order 39 CPC in the subject captioned as drafting, pleading and convincing. Before starting with the today's lecture, my dear students, I would like to provide you the concept behind temporary injunctions and also apprise you the meaning of temporary injunctions and also apprise you about the nature and scope and its object of issuing temporary injunction by the court of law in a civil suit. As the same is needed for the better understanding of today's lecture and thereby helps you to draft an temporary injunction application after looking into the grounds on the basis of which the same can be filed in a court of law by the applicant or by any of the party to the civil suit. So my dear students, let's start with the concept and the definition part of temporary injunctions. The law relating to injunctions has been provided in the Specific Relief Act. Injunctions, my dear students, are of two types. Number one, that is permanent injunctions and temporary injunctions. Section 37 of the Specific Relief provides that temporary injunctions are such as are to continue until a specified time or until the further order of the court, and the same may be granted by the court at any stage of the suit which is pending before it. Meaning thereby, it is one of the interim order which may be passed by the court of law during the pendency of the civil suit before it. My dear students, as you all are aware that the word interim means for the time being or in the meanwhile or temporary or provisional and not final or intervening. Thus, interim orders are those orders which are passed by the court during the pendency of a suit or proceedings which do not finally determine the substantive rights and the liabilities of the parties in respect of the subject matter of the suit or proceedings. Interim orders are necessary to deal with and protect the rights of the parties in the interval between the commencement of the proceedings and the final adjudication. So from this, we may infer that this is the object behind passing interim orders by the court of law in a civil suit. Now, before going further into temporary injunctions, I would like to apprise you with the various interim orders which are passed by the court or which may be passed by the court of law in a civil suit. These orders are orders pertaining to issuing of commissions. The law relating to the same is given under Order 26 of the Code of Civil Procedure. Second is arrest before judgment, Order 38. Attachment before judgment, Order 38. Temporary injunctions, Order 39. Interlocutory orders, Order 39. Receiver, Order 40. So these are some of the orders which may be captioned as interim orders. Further, Section 94, Clause C and E of the Code of Civil Procedure contains the provisions under which the court may, in order to prevent the ends of justice from being defeated, grant a temporary injunction or make such interlocutory orders as may appear to the court to be just and convenient. The procedure for seeking temporary injunctions has been provided under Order 39 CPC. So from this, we may infer that the temporary injunction has not been defined under the Code of Civil Procedure, but the same is defined under Section 37 of the Specific Relief Act, meaning thereby it has the relation, it has an interplay with the Specific Relief Act, that is the CPC. Further, what type of relief is it? That is the temporary injunction. An injunction being discretionary, equitable relief be granted when equally efficacious relief is obtainable in any other usual mode or proceedings. Next, what is the object behind issuing temporary injunction? The object of the interlocutory or the temporary injunction is to protect the plaintiff or the applicant, as the case may be, against injury by violation of his right for which he could not be adequately compensated in damages recoverable in the action if the uncertainty were resolved in his favor at the trial. So my dear students, this was so held in the case of Gujarat Bottling Company Limited versus Coca-Cola Company, 1995, 5 SCC, 545. Now, my dear students, before starting or before going to start with the drafting of an application, you have to consider the following essential ingredients which are necessary to be put in the drafting of the temporary injunction application. So these ingredients are: number one, it is well settled that for the grant of temporary injunctions, three factors have to satisfy. That is, prima facie case, balance of convenience, and irreparable loss. This was so held in the case of Dalpat Kumar versus Prahlad Singh, EIR 1993, Supreme Court 276. And Honorable Supreme Court or the Apex Court, as the case may be, explained these three factors as follows. There is a serious disputed question to be tried in the court, and that an act on the facts before the court, there is probability of his being entitled to the relief asked for by the plaintiff oblique defendant. So this is one of the factors for the consideration of prima facie case. Next. The court interference is necessary to protect the party from the series of injury. In other words, irreparable injury or danger would ensue before the legal right would be established at the trial, and that the comparative hardship on mischief or inconvenience which is likely to occur from withholding the injunction will be greater than that would be likely to be acted from granting it. Now, I hereby explain each and everything, every aspect, every ingredient of the temporary injunction application. Number one is prima facie case. Prima facie case does not mean that the plaintiff should have a 100% case, which will in all probability succeed in trial. Meaning thereby that the contentions which the plaintiff is raising require consideration in merit and are not liable to be rejected summarily. This was so held in the case of Prakash Singh versus State of Haryana, 2002, 4 Civil Law General, 71 Punjab and Haryana High Court. Next, irreparable loss. There are many injuries capable of being repaired, but a court of equity does not regard them as irreparable. So, irreparable loss is one of the essential ingredients of temporary injunction, or one of the essential elements to be considered by the court while deciding an application for temporary injunction. Irreparable loss means a loss which cannot be repaired, or meaning thereby which cannot be compensated in terms of money. Next, in Morgan Stanley Mutual Fund versus Karthik Das, Supreme Court observed as follows: where irreparable or extremely serious injury will be caused to the applicant, then ex parte order can be passed. So this is the case pertaining to the facts wherein an ex parte temporary injunction can be ordered by the court. And what are those circumstances? The first circumstance for the granting of an ex parte order oblique injunction are: number one, where irreparable loss or extremely serious injury will be caused to the applicant, thereby ex parte order can be passed. Second, the court shall examine the time when the plaintiff got notice of the act complaint. And third, if the plaintiff has acquiesced to the conduct of the respondent, then ex parte temporary injunction shall not be passed. Meaning thereby, where the plaintiff has already given his consent and it is revealed from his implied conduct or express conduct, then in those cases, ex parte temporary injunction would not be granted by the court. Next, the applicant shall be acted in utmost good faith, and such an order shall be for a temporary period. So the foremost condition for the grant of the ex parte temporary order is that such an order shall be for a temporary period and the applicant shall be acting in utmost good faith. Injunction is an equitable remedy as well as it is governed by law. Therefore, equitable principles are of very much importance in granting or rejecting injunction. Equitable principle is that he who seeks equity must come with clean hands. So from this we may infer that one must approach the court with clean hands. If he does not have the clean hands, then the court would not grant him the temporary injunctions. Next. What are the circumstances in which, or what are the cases in which temporary injunction may be granted? The rule regarding the same has been laid down by the legislature under Order 39 Rule 1 CPC. Order 39 Rule 1 CPC provides, number one, where any property is in dispute, is in danger. Second, where any property in dispute is being wasted. Third, when any property in dispute is damaged. When any property in dispute is alienated by any party. When any property is in dispute is wrongfully sold in execution of the decree. And number 6, when the defendant threatens the plaintiff. Number 7, when the defendant intends to remove the property from the lawful possession of the plaintiff. So these are the circumstances in which the plaintiff may file a temporary injunction application before the court of law, thereby to seek and to preserve his property from being damaged. Next, when defendant disposes of his property with a view to defrauding his creditors. Number 9, when the defendant threatens to dispossess the plaintiff. Number 10, when defendant otherwise cause injury to the plaintiff in relation to any property in dispute. In a suit where defendant is about to commit a breach of contract or other injury of any kind. And the last is where the court is of the opinion that it is in the interest of the justice so requires. So my dear students, these are some of the grounds on the basis of this to protect and to preserve the property. The Honorable Court may grant temporary injunctions in a civil suit to the applicant. Next, I would like to provide you the format of the application for temporary injunction under Order 39 CPC. So as you all are aware that the first and the foremost condition for filing an application is that the same is to be moved to the court which have the jurisdiction to try that particular suit. And such court has some designation or such court is being represented and or the title of this judge or the title or the designation of that particular court. So in the first and the foremost point to be considered for drafting is that you have to mention the name of the court or the designation of the court, which you may write it as under in the Court of Senior Civil Judge Delhi, as this particular case is deemed to be instituted before the senior civil judge, or the civil suit has been filed before the senior civil judge Delhi. That's why the same application needs to also to be filed before the same court. Next is IA number. What do you mean by IA number? IA means interim application number so and so of 2002 or 2020, as the case may be. That's why there is a dash, then dash is leaving for the sole reason that in first dash you have to mention the number which you get it from the court, and the second column is the year of the filing, that is 2020, 2021, as the case may be. In civil suit number so and so of so and so year, this number is also to be given by the court itself. In the matter of Mr. X versus Mr. Y, it's a case of plaintiff or the defendant, designation of the party you have to give. And you may also mention, along with the name of the plaintiff, the son of and the residence of the plaintiff and the defendant respectively. Thereafter, my dear student, you have to mention that the application has been filed under some rule, means the designation or title of that application you have to mention. And you may mention it as application under Order 39 Rule 1 and 2 of CPC for grant of temporary injunction. Next. Thereafter, you may write it as respectfully showeth. Thereafter, that the plaintiff has title suit in this learned court in which next date of hearing has not been fixed so far. You may mention that the same is pending before this court, or if the same and if there is any date given, then you may mention that particular date as well over here. Next, that the contents of the title civil suit may be kindly be read as part and parcel, because interim application is valid only till the pendency of the civil suit. That's why you are writing over here that the contents of the titled civil suit may kindly be read as part and parcel of the instant, may kindly be read as part and integral part of the instant application. Because the facts which have been mentioned in the civil suit are binding upon this application as well to the next, that the applicant has a good prima facie and arguable case and there is every likelihood of his success. So this is also one of the essential ingredient which I have mentioned in the case of Dalpat Singh, Dalpat Prasad, or as the case may be. Next is that the balance of convenience also lies in favor of the plaintiff. Next, that if the respondent are not restrained from alienating, transferring and selling the disputed property, irreparable loss will be caused or will be suffered by the applicant. So these are the essential ingredients which I have apprised you while telling you about the ingredients of temporary injunctions application. And in the end, you may mention the prayer which you are demanding or which you are seeking from the court of law in the given case which is pending before the court of law. So you may write the prayer as, in aforementioned circumstances, it is humbly prayed to this honorable court that the instant application may kindly be accepted and the respondent of the defendant may graciously be restrained from alienating, transferring and selling the disputed property till the disposal of the titled civil suit for specific performance. And at the end, you may mention pass any other order which this honorable court may deem fit in the facts and circumstances of the case. And then at the end, the applicant or the plaintiff, whosoever has filed this application, they have to sign that application. And the same has been filed under the instructions of the council, then the council may name be also given at the end of the application. So my dear students, this is all about today's lecture. In case you are having any query about today's lecture, then you may write to me at my email ID, that is rahularoda.gn@jagannath.org. But before parting with today's lecture, my dear students, I would apprise you with my new topic, which I am going to take in my next lecture. My dear students, my next lecture would be on drafting of appeal from original decree under Order 47 CPC. Thank you very much. Stay safe, stay home, and stay healthy. We'll meet you soon in my next lecture on drafting, pleading, and convincing. Thank you once again.